Well, that was greatly, very appropriate, I'm sure. Okay. Our guest speaker today is Jon, and this is the one thing I forgot to ask, Meador or Meador?
Meador.
Matter, not even close. Jon Meador, who will speak to us about his work as an attorney regarding the separation of church and state. Jon was born in Salem, Illinois, but spent most of his life in and around Austin, Texas. He is a second career attorney after spending roughly 15 years in the newspaper business. After leaving law school at 42, he began studying the Holocaust, the Nuremberg trials, fascism, the Enlightenment, and church and state separation. He retired from the Texas office of the Attorney General December 31st, 2021, and is looking to begin a small criminal law practice back in Salem, where he now lives. Jon says he enjoys giving this presentation and really wants feedback from us, so we will provide an opportunity for questions at the end of the presentation. Take it away, Jon.
All right. Can you all see that historical roots of church-state separation slide? Okay. Yeah. Thanks for having me. Like I said, I gave this at in Tampa at the AEU. This is a couple years ago, and I've tried to update it a bit, but I'm going to whiz through it. When I start thinking about church-state separation, when it comes to unite, I always start out with saying or making the argument, which is true, that the most important event in American history was the Reformation, which happened obviously in Germany in 1517, but the world really changed after that. And, about 80 years after the Reformation, Europe began settling the eastern coast of the United States. So I'm going to go through the slides pretty quickly because I want to get to the present day as quickly as I can. But the settlements started around the year 1600 generally. That's not a perfect number, but that's a pretty good number. And they were moving to the United States to purposefully expand on the Protestant religion, which is an interesting religion because there's really no such thing as the Protestant faith. There's not, there's no one institution. There's not one belief system, really. And the United States was really the petri dish, I think, for the Protestant faith, because if you moved here, you could always, like any other, Protestant religions, if you don't like, what your preacher is preaching at your Protestant church, you can just go across the street and start your own if you want to. That's not true of the Catholic faith or really the Jewish faith, but we do have to remember that people were really leaving Europe in order to sort of establish some religious liberty and also fleeing Roman Catholicism. So I'm going to go through this really quickly. But, if you lived in Great Britain, there was a time, you were, because the king was Catholic, you were Catholic. And then once, once it changed, one day you were Catholic, the next day you were Protestant, the next day you were Catholic, the next day you were Protestant. It just really depended on who was had the crown. So, of course, Henry wanted to get a divorce, and so he started the Church of England. And then Mary came along, Bloody Mary came along, and you were a Catholic again. And then Elizabeth came along, and then you were Protestant again. The Pope deposed Queen Elizabeth. James came along in year 1600. There was some belief that he might try to reestablish the Catholic faith. But essentially, my point here is that your faith was dependent on who the faith of the crown. I'm going to run through this quickly. We have a tendency to think that, the United States was settled quickly, but the Virginia Charter was 1606, Massachusetts 1620, Maine, New Hampshire. So really, it wasn't until around 1650 was there really much of a presence, I guess, on the East Coast. I know we were losing people quicker than when we were importing them. So people were immigrating, but there wasn't any population growth, I guess is what I like to mention. So let me go through the different establishments.
Jon, if I can interrupt you quickly, The
Yeah.
view that's displayed is not what you had wanted. It's showing us the current slide and the next slide and the notes view.
Oh my gosh, I don't know how that,
If you have two screens, it's probably that it's sharing the wrong screen now.
yeah. Uh-oh.
And I only interrupted you because I know you were trying to get it right.
Thank you for pointing that out. How about,
When you share your screen, just make sure it's the computer monitor that only shows this one slide, if that helps.
okay. Thank you. Give me 1 second. Let's see. What are you seeing now? Oh, this is so frustrating.
No, I think now if you just go to the bottom right and click this presentation button, it'll work.
Okay.
Yes.
Please work.
Perfect.
There we go.
Thank you, John. I'm
That
sorry.
better?
Yes.
Thank you for doing that. No, I tried to, that's what I was worried about. I had good reason to. I'm not going to go through this too quickly. It's not really debatable that, when people moved here, the idea that they came here to establish religious liberty was kind of a false. And I enjoy this letter from George II in 1679 to the governor of Massachusetts. He said that criticized the government for the persecution of dissenting religious bodies who did not agree with the congregational way. He said he found it ironic since liberty of conscience had been the one principal motive in the migration to America. So the point he's making is like, you claimed to move here for religious liberty, but you didn't really move here for religious liberty. You just wanted to sort of have your religion dominate. Again, law in America was ecclesiastical in nature in the 1600s, and that started to be phased out when people got tired of it. That third bullet point, there's a couple things in there. It was against the law to swear, curse, profane God's holy name. Of course, you had to obey the Sabbath. You couldn't you could be arrested or prosecuted for baptizing a child without authority, blasphemy, buggery, living a lewd and lascivious life. You could deny, if you denied the existence of God, or you declared the Bible is not the word of God, and that men nowadays can write as good a book as the Bible. So those are sorts of things, as you know, were illegal. And then we replaced the ecclesiastical law with the common law, and we started to see more toleration amongst the Protestant faiths, mostly because there's so many of them, so many Protestant religions. Like I said, if you wanted to start your own Protestant religion and build and have a religion different to the one you're attending, you can do that. You couldn't do that really with Catholic faith. We see in the 1600s sort of laws on toleration, but it was really tolerant as long as you weren't Catholic or Unitarian. And of course, the Catholics were no longer tolerant of the Huguenots in France. So that's sort of how it began to develop. But in the United States, even Cotton Mather was a fairly enlightened person. And the author of this book that I cite here was trying to make the point that in the United States, people like Cotton Mather generally were influenced by science and didn't see science as a threat. Where in Europe, science was a threat to the ecclesiastical authorities. It wasn't so much here because they didn't know better, really. And so this third bullet point is fun. It says that the essays now before us will demonstrate that natural philosophy is no enemy, but a mighty and wondrous incentive to religion. The works of the glorious God in the creation of the world are what I now propose to exhibit. Chrysostom, I remember, mentions the twofold book of God, the book of the creatures and the book of the scriptures. We will now for a while need the former of these books to help us with the latter. What he's saying is that, we start reading the Bible viewed through the prism of science. So I won't go through that too much because I'm getting behind. This is the revolutionary period where around, right prior to the Revolutionary War, Britain starts imposing various taxes and laws on the colonies really for the first time. So there were different acts that they were passing that affected the colonies. The Quartering Act and the Quebec Act is an interesting act because it established, quote unquote, the Catholic faith in Canada. Now, just more history there. The French lost the 7-Year War, and in 1763 they ceded Quebec. Now Quebec extended all the way down to the Mississippi and Ohio. So Quebec included Illinois, it included Indiana, Ohio, Michigan, and Wisconsin. So that's why you see so many French names down here. That was all part of Canada, and they established, quote unquote, the Catholic faith in Canada. And the founders of this country thought that was a threat because they thought, and specifically said, if Great Britain can establish the Catholic faith in Quebec, they could do it here. Now, they didn't establish the Catholic faith in Canada. All they did was allow the Catholic Church to collect tithes. So it wasn't like the Protestant state religion was prohibited in Canada. They just agreed that the Catholic Church could collect tithes. So the word established really has lots of synonyms, and one of them is collection of public funds. 1774, the Continental Congress, citing the Coercive Acts and the Quebec Act, told the colonies they needed to start writing their own constitutions, which they started to do, because obviously, if your grant of authority or if your colony is based on the grant from the king, and you're fixing to have a revolution against the king, those charters aren't any good anymore. So they told all the colonies to start writing their own constitutions, and I'm just going to take them in order because people also have the wrong assumption that the United States Constitution was one of the first constitutions written. It's not. It wasn't. So the people that gathered in Philadelphia to write the Constitution in 1787 had lots of experience, and so let's go through this. New Hampshire in January 1776, completely secular. South Carolina's Constitution was secular, but so help me God in the oath. Virginia, the Bill of Rights, completely secular, but you had the free exercise religion according to the dictates of your conscience. That's sort of famous. Virginia has a famous Bill of Rights on that. Delaware had a religious test, and you had to profess a faith in Jesus Christ. Pennsylvania, religious test. There was a notation that the Old Testament and the New Testament were divinely inspired, but you still had the right to believe to follow your dictates of conscience. Maryland had a religious test. North Carolina, you had to profess the truth of the Protestant religion. These are all different, obviously, constitutions because they're all separate. Georgia, representatives must be Protestant. There's the free exercise, and there was a provision for support of teachers. New York, free exercise, guard against the spiritual oppression and intolerance wherewith the bigotry and ambition of weak and wicked priests and princes. So they were sort of, you have the right to freely exercise, but we have to watch out for those weak and wicked priests. Then we had the Articles of Confederation, which mentions the great governor of the world. Massachusetts passed its constitution in 1780. There's a religious test. Again, the legislature could provide for the teaching of Christian teachers. Articles of Confederation ratified in 1781, and the United States was 1788. That's when it was finally ratified, with no establishment and no religious test. Connecticut and Rhode Island. I'm just going to go over the religious, I just sort of went through it. These are the specifics of some of these constitutions. I won't go through it too much. There's Pennsylvania. We know this was the sections, again, Virginia's constitution was sort of the blueprint of the religious, I guess the US Constitution's take on religion, mainly because Virginia's held so much power. Virginia was a huge state that extended all the way to the Mississippi. So it was kind of it's like, so the Virginians were very, obviously very persuasive because they just had a lot of power. This is the famous bill of Patrick Henry. I'd kind of like to focus, if I can, on the provision of public money to teaching Christian religion. Patrick Henry proposed a bill in Virginia for providing funds to teachers. And James Madison and George Mason sort of went ballistic, and they opposed it. And there were some different provisions. But again, this was a bill to provide money for the teaching to Christian teachers to teach Christianity. He wrote famously this memorial and remonstrance and opposing this. And I'm not going to go through a lot of it, but because he just went on and on and on. To say that he went ballistic is sort of really an accurate description. And the part that I've highlighted here, what influence, in fact, have ecclesiastical establishments had on civil society? In some instances, they've been seen to erect a spiritual tyranny on the ruins of civil authority. In many instances, they have been seen upholding the thrones of political tyranny. In no instance have they been the guardians of liberties of people. Now, this is James Madison talking, the father of the Constitution, and he was a preacher's kid too. Maybe explain some stuff, but he was opposed to it. He had to write this anonymously. George Mason was opposed to it, and George Mason was the author of Section 16 of the Virginia Bill of Rights. Again, this is a bill providing for the public funding of religious teachers. There were 1,522 signatures that accompanied this memorial and remonstrance. There was another petition that received almost 5,000 signatures, and this was probably less well known. But just sort of mentioned here, that the point here is that if we actually have to fund these sort of endeavors, then people will actually question the validity of the faith. So here's a mention that Constantine first established Christianity by human law. The church was overrun with error, superstition, and immorality. Religious establishment and government are linked together, and that the latter cannot stand without the former is something new. Establishment has never been a means of supporting the gospel. So pay attention to the word, how they're using establishment, because it comes up obviously in the free exercise in the First Amendment. They aren't using establishment in the sense as we are going to establish one religious faith or one religious, a religion for the state or for the country. They're using it as a synonym for funding. Here's a letter dated October 3rd from George Washington to George Mason. In response to this bill specifically, George Mason had sent George Washington a bill and said, "You know anything about it?" And George Washington said, "I don't know anything about it, but this is my feeling about it." He says, just in the bolded part here, "I am not amongst the number of those who are so much alarmed at the thoughts of making people pay towards the support of that which they profess, if of the denomination of Christians, or declare themselves Jew, Mohammedans, or otherwise, and thereby obtain the proper relief." He said, if they want a religious education, they can pay for it. And then he also went on to say, "I would hope that it's impolitic." And he at some point he says in there, he says, "I hope that the bill just dies an easy death." There's the next sentence. And the bill, in fact, did die an easy death. So they never did provide for the funding of Christian school teachers. I'm not going to go through this too much. Jefferson had that famous Bill of Religious Freedom, which Madison pushed in Virginia in lieu of that Henry's bill. In 1780, we're going to go to the Constitution now, when the federal government, and George Washington really wanted the federal government. They met at convention in 1787. This is to draft the Constitution. Again, these people had already drafted like 11 different state constitution, so they weren't novices. Rule. The first mentions of a religion in the Constitution, in the body of the Constitution itself, is the no religious test clause. And it was controversial when it went to the states, but according to the people that, favored it, said they, shouldn't have been controversial at all. It's like no one should have to profess a particular religion in order to serve either in the state or federal government as a, governor or a president or congressman or a judge. And it was somewhat controversial because they essentially carved religion out as a, how can people be moral and not be religious? Well, there you are. I think this is one of the more important provisions. And Joseph Story served on the Supreme Court, and he had some famous commentaries. And his commentary on this is that, notably in the boldface there, it has a higher objective to cut off forever every pretense of any alliance between church and state and the national government. So that's pretty powerful from a man who, like I said, was sort of a respected commentator on the Constitution. But that, to cut off every pretense of any alliance, that's that separation of church and state. I mean, it doesn't say it specifically, but any alliance between church and state and the national government. There it is. We don't really need the First Amendment as far as I'm concerned, but let's continue to go. This is a letter, again, after the convention. Madison sent Thomas Jefferson a letter about, this is how it went, because Jefferson was in Paris. And in his letter, he actually, this is more on the religious test clause. Other people weighing in on it. James Iredale served on the bottom person, served on the Supreme Court. And the bold there is, if any future Congress should pass an act concerning the religion of the country, it would be an act which they are not authorized to pass by the Constitution and which the people would not obey. Now, this is before the First Amendment. So this has nothing to do with the First Amendment at all. This had to do with this religious, sort of the power of not having a religious test. Again, I don't think we really need the First Amendment to tell us the separation of church and state. Let's see, where we go. This is that letter from Madison to Jefferson, telling Thomas Jefferson how it went. He mentions sort of, how are we going to keep people honest in this country? And he noted that some people would say, well, maybe religion is something, that will sort of be a way to keep people sort of part of the country, or at least, serve to make people want to be part of the country, be good citizens. This number 3 here, he says, as for religion, the inefficacy of this restraint on individuals is well known. So when you're saying, how are we going to keep people honest and democratic, do you think religion will play a part of it? When you say no, when you say the inefficacy of this restraint on individuals is well known, it's obviously not an endorsement of religion and how it sort of affects people. See, the conduct of every popular assembly and acting on oath, the strongest of religious ties, shows that individuals joined without remorse in acts against which their conscience would revolt if proposed to them separately in their closets. When indeed religion is kindled into enthusiasm, its force, like that of other passions, is increased by the sympathy of the multitude. But enthusiasm is only a temporary state of religion, and whilst it lasts, a little sensitive, will hardly be seen with pleasure at the helm. Even in its coolest state, it has been more oftener a motive to oppression than a restraint from it. Again, not a really complimentary belief in religion there by this is James Madison, the father of the Constitution. And see, now we passed the Constitution, but various states said, there's no Bill of Rights. We want a Bill of Rights. We want a Bill of Rights. I want to go through the progress or the progression of the First Amendment. So July 1789, the fourth proposition was that no religion shall be established by law, nor shall the equal rights of conscience be infringed. No state shall infringe on the equal rights of conscience, nor the freedom of speech or the press, nor the right of the jury trial by jury in criminal cases. So in this idea here, it was going to apply both to the federal government and to the states. August 15th, it changed to no religion shall be established by law, nor shall the equal rights of conscience be infringed. Now, these are all proposals. It's in the House. And at this time, we do have a government and a House and a Senate. So they went back and forth on drafting what would end up being the First Amendment. So this is the proposal. Eldridge Gary said, no religious doctrine shall be established by law. Madison's word, let's insert the word national. That didn't go over. Samuel Livermore said, Congress, how about proposing, why don't we make it say, Congress shall not make no law touching religion or infringing the rights of conscience, which is pretty close to what it ended up being. His bill passed that committee. The House approved, but it's still, we were wrangling with the language. The House approves, Congress shall make no law establishing religion or prevent the free exercise thereof or infringing the rights of conscience. That changed the next day to Congress shall make no law establishing religion or prohibiting the free exercise thereof, nor shall the rights of conscience be infringed. The Senate then got hold of it and said, Congress shall make no law establishing one religious sect or society in preference to others. The same day, but voted down, Congress shall make no law infringing the rights of conscience or establishing any religious sect or society. And Congress shall make no law establishing any particular denomination of religion in preference to one another or prohibiting the free exercise thereof, or shall the rights of conscience be infringed. And Congress shall make no law establishing religion or prohibiting the free exercise thereof. You're seeing it evolve. That's the point here. Senate sent to the House, Congress shall make no law establishing articles of faith or mode of worship or prohibiting the free exercise thereof. So they really had dual purposes. One was not only not establishing a particular religion to the detriment of other ones, but also not establishing articles of faith or modes of worship, which would be, let's see. Congress shall make no law establishing articles of faith or mode of worship or prohibiting the free exercise of religion. Congress shall make no law establishing religion or prohibiting the free exercise thereof, nor shall the rights of conscience be infringed. And then we finally settled on Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And then this is what I wanted to note. What I went through generally is called the legislative history of any particular, provision, whether it be a statute or what ended up being the Bill of Rights. One of my main arguments is they substituted the word respecting for establishing, because the word established, the idea that Congress cannot establish a national religion was shot down several times, as you noticed, because it didn't reach enough conduct. So they used the word respecting instead of establishing to reach not only, Congress can't establish a national religion, but they can establish a mode of worship, or articles of faith, those sorts of things. So the word respecting, when we have dictionaries from the period, sort of means, touching on or concerning, having to do with an establishment of religion, which to me means, we can't do piecemeal that which we can't do wholesale, which is what we can't do at piecemeal, establish a religion, which is, I think, of the tendency where we're tending to right now. It's like, it doesn't bar establishing religion, it bars everything sort of leading up to anything like an establishment of religion, which is the way James Madison described it later. I'm going to go on. This is, of course, the letter from Jefferson, when he saw it, make no law respecting an establishment of religion or prohibiting the free exercise, thus building a wall of separation of church and state. That's where it comes from famously. This is James Madison weighing in on the same subject. He said, we need to start strongly guard against this, strongly guarded as is the separation between religion and government in the Constitution of the United States. It's another way of saying it. The danger of encroachment of ecclesiastical bodies, maybe is illustrated by precedents already furnished in their short history. This is a reflection Madison had after the fact. And then the Constitution of the United States forbids everything like an establishment of religion. So that's, to me, everything like is, again, a synonym for the word respecting. Anything like an establishment, not just establishing a religion, but, everything and moving in that direction. The law appointed chaplains, and there's a footnote there, establishes religious worship for the national representative. So, it's somewhat controversial to have a chaplain in Congress, and here he's saying that's an establishment. He's, what is an establishment? Not necessarily establishing the Christian faith, but providing money for a chaplain. These are to be paid out of national taxes. Does not this involve the principle of a national establishment? So again, he's not saying we're establishing the Christian faith. It's this principle. In principle, it's an establishment, just like funding Christian school teachers. Let's see. And then here are some cases. You can, if you get on Lexis or Westlaw, which is the sort of search engines for lawyers, you can put in separation of church and state. You can get a few cases, but mostly separation of church and state developed at the state level and not the national level, because the states were really the ones that had their own constitutions, and the federal, the Constitution really didn't apply to the states until 1940, I think, was around the first. Again, we have one of the first cases was the anti-polygamy case that I think if it were brought today would probably be overruled. I think this Supreme Court would say that that the free exercise clause, they're really essentially trying to write the establishment clause out of the Constitution altogether. So I think if the Mormon Church, LDS Church, brought up this polygamy law, they'd probably win. The case in 47, this Everson, I think is what started it all. And my favorite Supreme Court judge, the case involved reimbursing parents for the fees that they paid to transport their kids to Catholic school, parochial school. That was a bus fare. And Robert Jackson, my favorite Supreme Court judge, which is the guy that he prosecuted the Nuremberg defendants, the Nazi war criminals, and then he came back and participated in this case. But in any event, the great purpose of the Constitution do not depend on the approval or convenience of those they restrained. I cannot read the history of the struggle to separate political from ecclesiastical affairs without a conviction that the court today is unconsciously giving the clock's hand a backward turn. It was a 5-4 decision allowing for the provision of reimbursing parents for the fees for the money they spent on getting their kids to school, to parochial school. And he said, which is, I think, prophetic, we're unconsciously giving the clock's hand a backwards turn. And basically what they said, you said you cannot discriminate against religious people. And they made the statement that there's, that the Constitution is not meant to be adversarial towards religions. And they used the sort of the phrase religion and irreligion, as if without ever recognizing that the Constitution is supposed to be completely neutral on that issue. It's school prayer case. And this is where Rehnquist seemed to indicate or hinted at that this is really not an establishment clause case, but really a free exercise clause case. And if you see the difference is, if the idea that teachers can lead kids in prayer, it's either an establishment clause or it's a free exercise case. I think it's an establishment clause case, but what he's saying here is really it's free exercise clause case. And again, no kid's ever been denied the opportunity to pray in school. I always argue it's just because there's a difference between teacher-led prayer and just personal reflection. I always joke that that's how I got straight A's in school is prayer, which is not true in any respect. So I'll go ahead and take questions at this point. I don't know what time it is because I will stop screen share if I can get over there.
It's 12
But-
minutes after the hour.
Okay, yeah, my personal opinion of where we are right now is that we really wouldn't be able to win a case in the Supreme Court based on making a historical argument about not funding sectarian schools, for example, because we just had that case come down, I don't know, 8 months ago, the Espinoza case, where they said if a state has provides for charter schools, which is really, private schools, then they also have to provide money to parochial schools or sectarian schools. And so I don't even know if a state now could get out of the charter school business in order to avoid funding Christian schools or religious schools, because they'd see that as discriminatory. So it seems to me that our only hope nowadays is legislative. And it's, we need to get judges on the Supreme Court who actually believe in the separation of church and state. I think it's so obvious. It's just, to me, it's so obvious, especially if you look at the legislative history. They weren't worried only about religious liberty. They were also worried about establishing a religion. And I think you can make an argument that establishing religion includes things like providing funds to religions to teach, their faith. And there are plenty of Supreme Court judges who used to think that. But, we have a whole new set of judges now who were, most people know that 40 or 50 years ago, the Federalist Society decided to work really hard and get other judges on the Supreme Court. And one of the things they wanted to do was to take down the wall of separation of church and state in order to provide funding for sectarian schools and other things. And there's so much momentum in the Supreme Court now that they've essentially said the application of the Establishment Clause discriminates against the Free Exercise Clause. It's like, it's stunning to me where it's really going. And I don't know, they've got so much momentum now. It's just hard for me to believe that there's any way we could show up in the Supreme Court and make an argument that would convince 5 judges that there still is a separation of church and state, or that the Establishment Clause is actually. There are people who say that, in the Federalist Society, who say that the Establishment Clause really doesn't mean anything. You could carve it out completely. It's so meaningless. And I don't think, historically, you can't make that argument. But if you get 5 judges on the Supreme Court, the earth is flat. It just depends on, and they have, spent the last 40 or 50 years trying to turn the balance of power on the Supreme Court. And they've got people up there now, Justice Clarence Thomas and Neil Gorsuch think that the Establishment Clause only prohibits the establishment of a national religion. Even though the words on the page say something different, even though the legislative history says something different, even though the historical, even though the comments of someone like James Madison would say something different, they don't care. They're just so tied into to that. So anyway, that's enough. I'll take any questions if people want to raise hands, or I don't know how I went through that so quickly. It's, there's a lot of material there. But again, I just don't think we have much of a leg to stand on right now based on the makeup of the court.
Why don't I start with the questions that are in the chat?
Okay.
We have one that says amphitheater or amphitheater.
Don't read that one.
Don't read that one? Okay. I'm sorry. I'm surprised that religious tax exemptions don't count as establishment, that by not requiring taxes, the government is in some way funding those entities, particularly today when so many churches are businesses in operation and function.
Yeah, when Madison wrote the detached memorandum, the one where he's talking about everything, the Constitution bars everything like an establishment. He doesn't say an establishment only, everything like an establishment. He said, in Kentucky, I'm hearing people say that the churches are getting tax breaks. What's that all about? He specifically said that. It's like, wouldn't he be surprised that, that churches don't pay any taxes at all? But the churches would argue there are other charities get tax breaks. But to me, religion is not like another charity. A lot of times religions don't do any charitable work at all, as a matter of fact. But it's the idea that, yeah, Madison would be shocked when people talk about, who was the main advocate of separation of church and state. I wouldn't mention Thomas Jefferson. I would mention James Madison. For everything that Thomas Jefferson said about it, James Madison said 5 or 6 more times, 5 or 6 things more about it. He was the main advocate of separation of church and state. But the Supreme Court just basically ignores James Madison unless they can use him to somehow advance their own belief that the free exercise clause is absolute and has no barriers at all. The free exercise, religion is the only thing in the First Amendment that has its counterweight. You have the right to freely exercise your religious beliefs. You have the right to free speech, freedom of press, freedom of assembly, and the freedom to petition your government for redress of your grievance. But, there are no counterweights to the right to petition your government for redress of your grievance. And there's no counterweight to the right to assemble or the right to freedom of press or the freedom of speech. Religion has a counterweight. And I think it's there for that reason. It's meant to make sure that that government doesn't freely exercise a religious belief. And one of the ways a government can freely exercise a religious belief is to fund it. No one seriously would make an argument that if they started, funding religions, that Buddhism and Hinduism and Islam would get a fair share of the money. I mean, they would get some. They would say, "Oh, it's only Judeo-Christian." And actually, Antonin Scalia actually wrote a dissent in one opinion in which he said, the free exercise clause was only meant to protect the Judeo-Christian faith. Can you believe that? The Supreme Court judge would say that. And they just have the audacity to say it. And then eventually, if you get 5 judges who believe it, that would mean every other religion is not constitutionally protected. Now, who out there right now doesn't believe that's possible with these judges? They might, they revere Antonin Scalia for some reason. I'm not sure why. But in that study, that you would basically disenfranchise every other religion besides the Judeo-Christian belief, even though, the founding fathers really hated the Catholic Church. That's why they left Europe. So, their parents and the grandparents and the great-grandparents, there were plenty of laws in place at the time of the founding of this country that made the practice of Catholicism illegal. And that religious test clause actually benefited Catholics a lot, because a typical religious test oath would be, I do not believe in the transubstantiation of the Eucharist. So is there another, are there more questions?
Two more comments in the chat. One is, I was struck by Madison's comment that religion is often used to get people to do awful things they would not do alone, or as an instrument to oppress or enable oppressive government.
Yeah, look that letter up. October, I think it's October 27, 1787. This would have been a couple months after the Constitution. They passed the Constitution, wrote it, and then they sent it to the states. So, we need you to ratify it. So he was basically checking in with his mentor, who was Thomas Jefferson, especially mentor on the religious clauses. Please look that up. It's a wonderful letter. But yeah, it's amazing. He says, religion has never been the protector of anyone's liberty. And that's exactly when Patrick Henry proposed that bill in Virginia for the provision of public money to fund Christian school teachers, you had all these people against it, religions. The Baptists were against it. Everybody was, the dissenting religions, the minority religions were against it. The minority religions were against it, even though it was providing public funds to Christian teachers, because they weren't going to get any of the money, and they knew it. And they also thought that religion did not need, and this is a sort of a Protestant, Martin Luther right down the middle. It's like the idea of 2 worlds. There's a temporal world, and then there's a supernatural world. That was part of Martin Luther and the Protestant faith generally, that there are really 2 worlds, the temporal world and for Catholics, that was never the case. Catholics could never see a distinction between government and religion. But when you have so many different Protestant faiths, the dissenting religions want separation of church and state. Once they get in power, like that letter from King George to the Puritans, like once you get in power, it's like all of a sudden you don't believe in religious liberty anymore. You only believe in the Puritan religion. So it's like, that's the danger of religion, because once you get in power, once all of a sudden you lose your toleration for other people. Nice thing about the Protestant faith is that there really is no such thing as a Protestant faith. I mean, there's no one Protestant position on abortion or contraception, or even the Trinity. I mean, you'd be hard pressed to find any of the first 5 or 10 presidents who believed that Jesus rose from the dead, including George Washington. They just didn't. They were more along the lines of a deist or Unitarians than anything else. So I could go on and on and on about it, unfortunately.
Okay.
Okay.
Nick,
Yeah, but look that letter up. Please look that up and read it yourself.
It's just so parallel to what you see today with all the so-called religious freedom bills and stuff. I mean,
and they're just, people can, Americans United and freedom from religion and the American humanists, they just cannot, they don't have, those folks have hundreds and hundreds and hundreds of millions of dollars.
mm-hmm.
And, if our side of the ledger had $1 million, I'd be shocked. But, the Heritage Foundation, the Federalist Society, Alliance Defending Freedom, supposedly, these people have hundreds and hundreds of millions of dollars, and they are introducing bills all over the place, hoping that they'll stick. And, if they get in front of the Supreme Court, guess what's going to happen? They're taking the wall down brick by brick. And that's why I say that our only cure here, our only way to get out of it is legislative. And we're going to have to put more judges on and unfortunately, our side, we don't play by the same rules. We have a tendency to be too fair and just like, we're going to but what, if we let this go on for another 10 years, you will see that there was no establishment clause at all, because every time the establishment clause is applied, somebody's going to say, oh, my religious freedom is being infringed on, even though that's exactly why the establishment clause is in there. They'll always make the argument that somehow my religious liberty is being infringed on. So it's amazing.
okay. We have time for maybe one last quick question and answer.
Okay. Is that the one in the chat?
If you want to take that one, that's fine.
Could there be an argument for what is taught or how it is taught to prevent funding brainwashing institutions for children in the guise of schools? I witnessed firsthand the lack of education, even the basic English and math, much less science, in faculties operating as evangelical. Yeah. One of the reasons why they started, the Supreme Court allowed for vouchers was that the public school system was so poor that it was a way to really sort of allow parents to put their kids into a private, a better, school with a better education. You can make that argument, but every time you show up in the Supreme Court and you say, oh, these religious schools are really filling their kids in heads with a bunch of garbage, you'd get yelled at. I mean, they would just probably get livid. It's hard to, they're so pro-religion now that it's hard to make, it would be hard to make that argument. Also, I don't, some states sort of hide this, you can't really raise, you're not supposed to look into the tenets of a religion, and you're not supposed to really, we're just at a point now where you just can't be critical of it at all. It doesn't matter what they're teaching. It's a completely 180 degrees from where we were 70 years ago or 80 years ago, only because we have different people on the court. It's not because the laws changed. They just, like I said, there was a concerted effort to put people on the court who wanted to take the separation of church and state down. And it's like I said, if you get 5 judges on the Supreme Court, the earth is flat. And really, literally, that wouldn't surprise me. I wouldn't be surprised if they didn't go after evolution and require creation and require creationism to be taught alongside of everything else, out of a sense of fairness, out of a sense of, what harm is there to it? And so, again, I think our only remedy is going to be legislative. I don't think we can make an argument anymore and really get 5 votes. It'd be tough. So yeah, as far as making, I guess you can make an argument that it's sort of a waste of, yeah, it's going to bad uses, but then you'll just get jumped on for bringing that up, I think.
I'm afraid, John, we have to stop.
Sorry. Okay, I'm sorry. Dominated.
Um,